Thank you all for coming to the Floersheimer Center for Constitutional Democracy's first event of the semester. You're all here to talk about and hear about religious liberty and the future of the Supreme Court's First Amendment jurisprudence. But before we dive into that, I do want to put in a plug for our next Floersheimer Center event, which is coming up very, very soon on Wednesday. Let me get the day of the month correctly. Wednesday, March 22nd. Will be another panel here just like this, talking about the role of state courts in election law and election litigation. We'll be joined by a number of scholars and lawyers and government officials who do that kind of work, moderated by my colleague and co-director, Professor Deborah Perlstein. So stay tuned for that in just about a little over 2 weeks. With that said, let me introduce briefly our terrific panelists, and then we will begin. First, I'm just going in alphabetical order here. So two people to my right is Giselle Clapper. Giselle is Senior Staff Attorney of the Sikh Coalition. In this role, she provides expert legal assistance to Sikhs who have been discriminated against on the basis of their Sikh identity or beliefs, including in cases involving hate crimes, school bullying, profiling, and workplace discrimination. She also represents clients on a variety of civil rights issues, including securing accommodations for Sikh articles of faith and advocating on behalf of hate crime victims and ensuring that law enforcement adequately understands and addresses anti-Sikh bias. Prior to joining the Sikh Coalition, Giselle had a significant career in international human rights law, working at the UN Office for the High Commissioner for Human Rights in Kosovo and at Human Rights Watch in Belgium. At the far end of the table is Mark Movsesian. Mark is the Frederick A. Whitney Professor of Contract Law and co-director of the Center for Law and Religion at St. John's University Law School here in Queens. He teaches and studies law and religion, comparative law, federal courts, and contract law. His work has appeared in numerous fancy law reviews I will not list in great detail, as well as a number of media outlets. Before teaching, Mark clerked for Judge Harrison Winter of the Fourth Circuit and Justice David Souter of the Supreme Court, and worked at the Department of Justice in the Office of Legal Counsel. Next to Mark is Liz Platt. Liz is the Director of Law of the Law, Rights, and Religion Project at Columbia Law School. Before joining Columbia, she was a staff attorney at MFY Legal Services Mental Health Law Project and a Carr Center for Reproductive Justice Fellow at A Better Balance. During law school, Liz worked with the Urban Justice Sex Workers Project, the New York Civil Liberties Union, and the Brennan Center for Justice. And I'll point out, of course, that she is an alum of NYU Law School, just like myself. And then finally, on my right is Nelson Tebby. Nelson is the Jane M.G. Foster Professor of Law at Cornell Law School, where he studies, would you believe, freedom of religion, freedom of speech, and constitutional law. Nelson is the author of Religious Freedom in an Egalitarian Age, where he examines the contemporary conflict between free exercise and equality law and argues for a way forward that protects civil rights while safeguarding the ability of religious traditionalists to dissent. I'm sure I'll be talking at some length about that work here today. Like Mark, his articles have appeared in fancy law reviews and media outlets and so on. Nelson clerked for Judge John Walker of the Court of Appeals for the Second Circuit and practiced law at the ACLU and at Davis Polk. So with those introductions out of the way, let me do one last bit of housekeeping business, which is thank our terrific program staff. Katie Sigmund is one of our student fellows who has taken the lead on this particular event. And our intrepid program director, Hui Yang, right up there front, who is integral into all of our programming efforts. So with that out of the way, I'm going to structure this like hopefully a conversation. So you're going to hear less from me and more from these expert folks who you actually came to hear from. And so what I want to begin, and I'll throw this to Liz first, just to take the first swing at it, but then everyone else who wants to chime in, please feel free to do so, which is, what do you think are the most significant types of religious liberty cases, religious liberty issues that are likely to be on the horizon for the courts? And how do you think the courts are likely to engage with and resolve those significant issues?
Sure.
It's a big question. Yeah.
So I'm going to outline, I think there's so much activity happening. I think religion in the courts has really just exploded in terms of the quantity of cases we're seeing and that the Supreme Court is taking. I'll run through a few things that are already on deck. This term, the court is going to be deciding 303 Creative, which is a free speech rather than religious liberty, but there's a lot of overlap there. Case involving the right to turn away particular customers based on, sorry? Oh, okay, there we go. My apologies. The first case I'll mention is 303 Creative, which is a free speech case involving the right of for-profit businesses to turn away particular customers based on the owner's religious belief. And we're seeing that's just one of a host of cases working their way through the court system involving a range of different businesses and employers seeking a right to turn away primarily, but not exclusively, same-sex couples seeking services, but there are also cases involving, for example, foster care agencies who have turned away Catholic and Jewish families seeking services. After the Supreme Court's cases involving religious government funding of religious institutions like Trinity Lutheran and Carson v. Macon, which involved funding of religious schools, there's still a very much an open question we're going to be seeing regarding whether the government can place any limitations on religious institutions kind of in exchange for their receipt of government funds. So we're seeing government funding of religious institutions, but can the government then say, and you have to abide by particular grant restrictions, for example? Huge open question regarding what remains of the Establishment Clause of the U.S. Constitution in the wake of Kennedy v. Bremerton, which was the praying football coach case you may have heard of regarding whether in which the court found that a football coach at a public school had the right after the game to engage in public prayer. In the past there had been student engagement in that prayer. And so in the wake of that, the court completely eliminated a very long-standing Establishment Clause test called the Lemon Test in favor of a more originalist approach to the Establishment Clause, citing history and traditions. It's a brand new test. We have no idea what's going to happen or where it's going to go. And the scope of the church autonomy doctrine, we've seen religious institutions exempted from not just longstanding things like the right to discriminate in the selection of ministers, but increasingly religious institutions allowed to do things like engage in like actual explicit sex discrimination, for example, issues regarding the right to abide by certain forms of contract law even. And so I think there's a lot of open questions with how far religious institutions can go in violating a range of different laws. And then I'm going to just throw out one last kind of, I think, a little bit less discussed issue, which is I think that we've seen a wave of religious exemptions related to discrimination and LGBTQ rights, a wave of religious exemption questions in the wake of COVID restrictions. My one prediction, a wave of religious exemptions related to contraceptive and abortion care. One area I think in the wake, particularly of the Hobby Lobby cases, perhaps many more cases involving labor rights. So for example, religious colleges have been granted religious accommodations, essentially a right not to recognize unions, for example. And that's one area where I think we might see increased activity. So I laid out a lot. I want to give other folks a chance to weigh in on some of those, but those are, I see some of the key issues. And I think we'll get into where the court is going to land on some of these particular around LGBTQ rights and reproductive rights. I think I'll save that for a bit later.
Okay, great.
Oh, no, well, I mean,
You look like you had something to say.
No. I mean, I was very interested. I agree with what Liz said. I think those are the issues that are coming up, and I think it's an area where there's a lot of ferment right now. I think that's absolutely right. The only thing I would say a little different, I think, I'm not sure that the Bremerton case is really an originalist approach, because they're talking about history and tradition, which I think would be something post-enactment. I don't think it's just the original meaning. I think it's as things develop over time. But I completely agree with you that we don't know what it is, and that we're just going to have to see over time what the court does with that. I'm sorry, could you hear? I wasn't saying anything that important. I said I agree with everything Liz said. The only maybe quibble I would have is Liz characterized the new Bremerton case as an originalist opinion, and I said I wasn't sure that it was an originalist opinion because the court stresses the importance of history and tradition, which would be post enactment of the Constitution. So not what the First Amendment meant in 1791, but actually what developed over time. But then I said, I also agreed with Liz that we don't know what it means really, because the court just has to develop it.
And of course, a lot of the courts across the board, a lot of the court's originalist jurisprudence has also relied on history and tradition, post-enactment history and tradition. As long as it's old enough, it sort of counts as.
Yeah, well, this gets us into a whole debate about what is really originalism. There's a lot of ferment in what is originalism too right now. Even originalists can't agree about that. But I would have said that if you're looking to how something develops over centuries, that really isn't originalism anymore. That's something different. But this is in the weeds, I guess.
Nelson, Giselle, anything to add on sort of the big issues you see on the horizon?
Yeah, well, I mean, I guess I would say like we're likely to see change across every single area of religious freedom doctrine. I don't see stability in any of the areas that the Supreme Court is likely to touch in recent in the coming months and years. I tend to think about three big buckets. Like there's one bucket which is about government funding of religion and the limitations on government funding. And then there's another about government expression around religion. Can the government, engage in prayer or and that kind of thing? And then third, religious exemptions. So would individual religious actors get exemptions from general laws that the rest of us have to follow? And I think in all three of those areas we've seen recent changes and we're likely to see further changes. So for example, with respect to government funding, which Liz mentioned, we've already seen a move from, an era of jurisprudence where, the question was, whether governments would be allowed to fund religious groups. And then there was, whether they would be permitted. Sometimes they were prohibited by the Constitution, then they were permitted by the Constitution to fund religious groups. And now they're required under certain circumstances to fund religious groups. So the next question I agree with Liz is, well, what if a government, abides by that rule, but then wants to set conditions on the funding? So the state of Maine, which was at issue in Carson against Macon, now has to fund as part of its school choice program, religious private schools. But can it say, if you're going to receive government funding, you also can't discriminate against LGBTQ students or teachers? Or is that itself a religious freedom violation or restriction? That I think we're likely to see that question come up like relatively quickly, and I don't see stability around that question, unlike some other commentators. With regard to government expression, the Kennedy against Bremerton football coach case is the most recent word from the Supreme Court, but it really opens up more questions than it answers. The methodological question about what does the history and traditions approach mean is one of those, but they're also quite practical questions. Like now we know that public school employees can publicly engage in prayer as long as they're not sort of it's before the classroom bell rings or after the classroom bell rings to signal the end of class. But what that means for, official school prayer that is sanctioned by the school is, I think, very unclear. And so the endurance of the school prayer cases from the early 1960s is, to my mind, in question. And then finally, around religious exemptions, I think Liz Platt is quite right to say that we'll see, we have seen changes with regard to the ministerial exception, which is, now applies to school teachers, for example, and other positions. But it's not only in those kinds of settings that change is afoot. The Supreme Court is considering a case right now about Title VII, which is an employment discrimination. So the main federal employment discrimination law, it provides for accommodations for religious employees, but the Supreme Court has construed that provision quite narrowly, and it will almost certainly this term expand the ability of religious employees to seek exemptions, even when that shifts burdens to other employees or to their employers. So in all these areas of law, I think we've seen recent changes, and I think we're likely to see further changes.
Is there anything you want to add?
No, I was actually going to talk about the one you just talked about, Nelson, the Graffiti de Joy, but it's the employment case, just because it's an area of the work that I work in that we follow a lot. So that one, I think everyone here probably agrees it will likely change the undue hardship standard, but that's something to, I guess, look out for.
I think the issue of employer-employee conflicts will be really interesting too, as the court expands religious rights both for employers and for employees. That's going to come to a head at some point.
Right. I mean, I think something that comes up in a lot of what Nelson was saying, and Liz, and what you were just saying too, is that expanding religious rights, expanding religious liberty rights for some means often expanding them for others as well. And the conflict is not always religion versus secular or religion versus law, but religion versus religion, and how the law sort of might or might not be able to accommodate or resolve that kind of conflict. Anything else on this point? Well, it's actually a good segue to the next question, which is, so a lot of these cases that we were just talking about have to do with, or the praying football coach and so on, the challenges to employee coverage contraception that Liz was mentioning. Most of these have been brought by members of a Christian faith. There are other cases the court has handled that involve both in the court sort of history of the jurisprudence, but even recently, Jewish claimants, Muslim claimants, and so on. I guess so, Giselle, given your work, I want to begin here with you. How do you think the court is likely to, or I shouldn't put it on the court as the subject of that sentence. How do you think religious liberty claims from more minority religions are likely to fare relative to those of Christian plaintiffs or Christian claimants?
That's a question we ask ourselves every day, unfortunately. It's a really good question. I think two things on the case we just talked about, because again, it's kind of my area of expertise with the cases we work on. Graffiti de Joy, I think, is super interesting with the undue hardship standard, because I wasn't there at the time, but the Sikh Coalition and the ACLU and a bunch of organizations back in 2009 started a campaign in California it was like an advocacy campaign. They couldn't go through. I'll talk about the case if anyone is interested, but there was no legal route, I guess, or legal action. So they started this advocacy campaign to change the standard under FEHA, the California State Employment Discrimination Law, to make it the same as the ADA standard in how you interpret undue hardship, which is the question now, right, that the Supreme Court is going to answer. And that happened in 2009. There was a case with a woman who was sick and wanted to wear a turban at work. She was a police officer. And it's all those questions of appearance, right? And customer preference and things about sort of customer facing positions. And her accommodation she was given was what we would consider segregation, where she was put into a desk position that had nothing to do with, the qualification she had. So that's what started this campaign. I say this to say, I think it's interesting to see how that, when you look at it through the minority faith perspective, it took, I think it wasn't until 2012 they passed the bill. And then finally her supervisor at work said, the law changed, we obey the law, so you can wear your turban now and have the job you wanted 3 years ago. So that's one thing I think is interesting and very likely will change now with Graffiti de Joy, which, there's all those questions about, are we inadvertently, taking away rights from marginalized communities, which I think is a very important question. But when it comes to, I would say, religious minorities with that case, I think it will help in that sense. Because it's a very hard standard to meet for them otherwise, and employers can just deny their accommodations, especially again, when it comes to just things like appearance, right? If a Sikh person wants to wear a turban and a beard, that's them practicing their religion. It doesn't take away from anyone else's rights, actually, right? So that question of third-party harm, I think is, something I think about a lot.
Years ago, I had a student who wrote his law review note about third-party harm in religious land use accommodation. So anyway, when you said that brought me back. Anyway.
I mean, so most people think that the changes that the Supreme Court is implementing across the issues that I just described are pro-religion, right? That's the sort of view, the sort of headline view if you read a newspaper or something. But I guess where I would start when thinking about minority religions is with the Establishment Clause. Because if you think about religious freedom as including anti-establishment, then it's far from clear that the changes the Supreme Court is implementing will be good for all religious groups, especially smaller religious groups. And so just, just to get your mind around that, you might think like, well, if the government has an established church, right, that's not going to be great for people who don't belong to that church, right? For a variety of reasons. They may suffer reduced citizenship status just as a matter of like cultural power, right? And in democracy, like that ought to be, something of significant concern if one of our main values is political equality. But in other kinds of ways too, like it may be more difficult for minority religions to practice their faith if federal dollars are mostly flowing to the largest faiths and so forth. So it used to be the case that during the middle of the 20th century, when separationism was like a constitutional value that was enforced by the Supreme Court, that some of the main proponents of that worldview were, Jews, especially, liberal Reform Jews. And you don't really see that anymore. In fact, like as a cultural matter, it seems like the separationist impulse behind the Establishment Clause like has very little political traction with anyone. Like it seems to be like a norm that's like sort of fallen by the wayside. But that doesn't mean that abandoning separationism, won't have effects for minority religious groups and also for non-believers. So that's just one thing I would add to the conversation about this.
One thing I wanted to maybe provocatively poke at is so one of the to combine culture wars for a second, there are, as I'm sure you're all aware as well, a number of cases being litigated by Jewish, Muslim, and other faith organizations challenging abortion restriction laws in a number of states on the basis of religious liberty. And so, to a court that is evidently sort of pro-religion in the ways that you were just describing, Nelson, but is also, given the court's decision in Dobbs, not inclined toward challenges to abortion restrictions. How do we think courts are likely to resolve that kind of conflict? And that's just to sort of take that as an example. Do you anticipate courts sort of looking more closely at sincerity, or using the sincerity tool as a way to limit the scope of religious liberty claims, degree of observance? I could imagine courts concerned about floodgates problems if, as it moves down the road toward greater acceptance of religious liberty claims, those same judges concerned about, well, now how do we tame this monster that we've unleashed? What are some ways that you think courts might do that? And would those be sort of even-handed in their impact on minority communities and not?
I mean, the religious right to abortion cases is something I have a particular interest in, and have, organization issued a report on them on August if folks have interest. It's obviously naive, I think, to think of to not recognize the politics behind religious exemption cases in general. And I mean, if you just look at the Supreme Court decisions where I think religious minorities have succeeded before the court is in cases where there's not another competing interest that the court feels very deeply about. So Holt v. Hobbs, the court unanimously found inmate had a right to a 1/4-inch beard. In the Trump v. Hawaii, the court upheld the ban, despite this vast history of anti-Muslim animus motivating the ban, when a couple weeks earlier it found in Masterpiece Cake Shop performed a really searching review regarding religious animus to find in favor of Jack Phillips, the baker who turned away a same-sex couple seeking a wedding cake. In the Muslim ban case, the court, I think, felt very deeply about had very deep concerns about national security and kind of the national sovereignty, and blanking on the term I want to use, but so I think certainly this Supreme Court, I do not imagine finding a free exercise right to abortion. That said, these cases are almost all being litigated in state courts, where there there may be more flexibility, there may be more openness to these arguments. And I think it really depends on kind of the specifics of the approach. For example, there's a case I find very compelling in Kentucky with 3 Jewish women who've argued that they have a religious liberty right to get IVF. I think that's a really interesting case. Regarding sincerity, I'll just say really briefly, I mean, again, courts have almost unanimously been loath to really probe deeply into religious sincerity unless it's an already disfavored claimant. It's someone in prison, it's someone facing a criminal charges, maybe back in the day, like conscientious objectors from the draft. So I don't imagine that trend to kind of change too much.
Thank you. By the way, I'm remiss. I should have said thank you very much for having me here. I really appreciate being invited, and thanks to Hui and to Katie and to you, Michael, for having me. So thank you very much. I was here 20 years ago teaching, actually, so it's the first time I'm back, and I'm glad to be back. I guess I would just have 2 comments on this. One is with respect to minority religions. I mean, I think it differs depending on where you are in the country, of course, but I think that some traditional Christians would say they are kind of a minority religion in some places. I think if you're in Colorado and you're Jack Phillips, I don't think you think that you are particularly powerful in the political process, even though you're a traditional Christian. So, but of course that differs in other parts of the country. So I think that's something to keep in mind. Second, I think, Liz is right. There's a lot of foment out there. And one of the problems, I'm going to get to this a little later, I think, but one of the problems is it seems like we're moving to a strict scrutiny test for most of these cases. And strict scrutiny, which says that if there is a substantial burden on religious exercise, there must be a compelling state interest, and the rule must be necessary to promote that interest. That is inherently an indeterminate test. And it's not formally a balancing test, but judges typically use it as a balancing test. And there's really no neutral way to balance these things. The balance will depend on your values coming in and what your prior commitments are. And we're at a point in our country, I think, where values are just very different and people see very differently. So, Liz is saying maybe in Kentucky it'll come out one way, maybe another state a different. I think that's right. And I think that's because we haven't really reached a national consensus on a lot of these issues. So I think, buckle up with respect to these cases, because I think they all raise very serious issues, including the ones Liz is talking about. And it's just given the kind of lack of consensus, it's hard to see what the uniform view on these cases is going to be.
I can add just one example. It's not technically First Amendment, but under the Religious Freedom Restoration Act, one case that we're currently working on that I think is interesting in the context of this conversation that has not yet gone to the Supreme Court, but could, so we'll see, is a case that we have where we're suing the Marine Corps on behalf of Sikhs who maintain turbans and beards and were not allowed in with their turbans and beards for arguments for reasons based on like appearance, right? Not about safety when you think of compelling government interests, not about mission accomplishment, just about uniformity. Everyone has to look the same. No surprise, it's the same arguments that were used against integration of Black people into the military, women, it's the exact same. So all the branches of the Department of Defense in the US have started accommodating Sikhs, Muslim women who may wear hijabs, Jewish service members who, whatever it may be, right? Religious articles that don't sort of fit the mold that was created when it started. All the branches accommodated, and then the Marine Corps was the last one. Again, unsurprisingly, it was also the last one to integrate any other minority. The reason I bring this up is what I find interesting about this. So right now we're, again, not at the Supreme Court yet. We started at the district court in DC. We actually lost. That was very surprising for our team because they had won against the Army. There's precedent, there's case law, there's a lot of case law. And we lost at the district court on a PI. We, asked for a preliminary injunction for the recruits to be allowed, our clients to be led into boot camp because they were being told, sure, you could be a Marine and a Sikh and have your turban and beard, but first you have to train. You have to go to recruit training, you give it up like everyone else, and then you can be a Sikh again. So that was the case. We lost at the district court. We luckily, or I guess thankfully, I don't know, for our clients, won at the Court of Appeals level. It's not over. This case had 2 phases. We're starting the second phase right now that is on the limitations placed on their accommodations. I think that could go to the Supreme Court. And I will tell you what I tell my clients. I don't feel very comfortable with that if it did come to that, because I don't know how we would fare, honestly, even on that standard, right?
Could I add just one last thing? I'm sorry, because it's sort of a hobby horse of mine. I think another issue about minority religions is the nuns, the religiously unaffiliated. That's like 20% of the adult population right now. These are people who say
Nuns, N-O-N-E.
N-O-N-E-S, right? Not with the habits, right? Nuns. And these are people who say we do not belong formally to any religion, but we have our own faith. We have a sort of an idiosyncratic faith that draws from lots of different traditions. And these people are starting to appear in the cases now, bringing religious claims in some of the COVID cases. And, what does a court make of those claims? Because they're not really in a religion unless you say everybody can be his own religion, which causes all kinds of problems. So I would just say that's, I think, lurking out there as another minority religion issue.
Mark has a great article recently published called "The New Thoreaus" on that subject. I totally recommend it. Can I just say a couple things about the? Okay,
Absolutely.
so first on the abortion exemption claim. So these are liberal religious people bringing claims for exemptions from abortion bans, right? I would say that as a matter of doctrine, as it's been set up by the Supreme Court, these are straightforward cases. Straightforward. These claims are very straightforward, right? The idea is because these states often have exemptions for other people, including people who are seeking IVF, which is quite a clear exemption, not in that state, but in other states. The idea is that, well, that renders the law then, not generally applicable. It's, in the language of the Supreme Court, in cases that it's set up like quite recently, that means the law is discriminatory on the basis of religion and strict scrutiny should be applied. It's very hard to satisfy strict scrutiny when the state has said, we're going to allow some people to terminate their pregnancies, but not you. That's exactly the kind of claim that the Supreme Court has been very sympathetic to in recent cases. So as a matter of doctrine, these cases are straightforward, right? You would expect them to win. It's also very clear they will not win. They're not going to win in the Supreme Court. Liz, who's I think the nation's leading expert on these cases. I really do. I think it's true. She's the nation's leading expert on these cases. Said, well, a lot of them are being brought in state court. That is true. But remember, these are states with abortion bans, right? So, the state politics aren't the same, necessarily consistent across the legislature and the executive and the highest court of the state, but they often are, right? So whether you can expect success in state court, I think is open to serious question as well. On sincerity, look, people like Josh Blackman have questioned the sincerity of these Reformed Jewish women who are bringing these kinds of claims. And in other kinds of cases, Doug Laycock has questioned the sincerity of Christians who are asking for exemptions from vaccine mandates. So these kinds of sincerity arguments are being raised, but I don't expect them to be successful in court. I think courts will continue to pause before they question the sincerity of religious plaintiffs who are bringing these kinds of claims. However, I do think that threshold requirements are going to be important. But I expect that the threshold requirement that the court will reinvigorate, if it does reinvigorate one, will be the substantial burden threshold. That is, the requirement that the burden on your faith be substantial before you can trigger strict scrutiny, as Mark was saying. There are a line of cases from the 1980s in particular, where the courts really did police this idea of substantial burden. And Doug Laycock has argued, I think very persuasively, that if we're going to allow strict scrutiny to be applied across, or if that's going to be the rule, right, if that rule will be available across a range of cases, we're going to need some threshold bulwarks, right, against the application of strict scrutiny. So that's where I would expect to see development, although I'm not, prognostication is not my strongest suit.
And Liz, you mentioned Hobby Lobby earlier. I mean, that's a case, again, not constitutional, but in the RFRA context, right, where the court really lowered that substantial burden bar in an effort, to then, quickly trigger strict scrutiny. But so, Nelson, maybe there'll be a sort of backing away from that in the constitutional context, at least. As a way of policing that.
I think there has to be. I mean, look, there are three threshold requirements for exemption cases. First, your claim has to be religious, right? Which is a problem for the nuns unless they can, which many have actually, sort of characterize their claims as religious in some way. Second, you have to sincerely hold those beliefs. third, there has to be substantial burden on your beliefs or practices. Of those three, I think the one that is easiest to police is the substantial burden test. So we'll see.
So on that note, let me move on to Nelson. Tell us about your book. No, the question is does there need to be, is it inevitable that there is a conflict between religious liberty and other civil rights? Does it need to be a zero-sum game? Or is there a way to, in constitutional doctrine, in policy, to compromise or accommodate both sorts of claims? And what would that compromise look like?
Yeah. So I think that it is possible to compromise, and that sensible compromises are available and have been struck in the past. But to see that, I think it's helpful to sort of take a step back and look not just at the recent history, but history of conflict between civil rights laws and religious freedom claims across several decades, beginning in the middle of the 20th century, let's say. And if you look at it with that kind of frame, you can see that compromises have been struck all along, and some of those compromises are relatively stable. They were stable for decades. So I'll just give you a few examples, like Title VII. The Title VII, which governs employment discrimination, has an exemption that allows religious organizations to favor members of their faith. Also, the ministerial exception allows and has long allowed clergy to be chosen without regard to civil rights kinds of protections, especially where the doctrine of a particular faith requires that. So, for example, the Catholic Church only hires men as priests. That's illegal under employment discrimination law. But most people believe, I think everyone believes, this is like a matter of widespread sort of consensus that there ought to be constitutional protections for Catholics that want to hire only men as priests, and analogously for other faiths. The Mrs. Murphy exception from housing discrimination law. Oh, this is your bailiwick.
My students just learned this a week or two ago.
Allows landlords who live in the building and whose building isn't too large to be free of housing fairness rules, so that they can select in discriminatory ways who lives in the building. That protects religious landlords along with other kinds of landlords. Title IX has an exception for religious colleges and universities, right, from its protections and so forth, right? It's not like we haven't had experience striking these balances. We have as a nation. We've done this for a long time. But those kinds of compromises have been unsettled recently in the context mostly of LGBTQ rights and reproductive freedom. But not only in those two areas, across a range of other areas as well, including cases concerning race discrimination. Suddenly, the kinds of compromises that we've struck over a long period of time are being unsettled and reworked. And I think the argument that I make in the book is that we ought to pay close attention to that kind of situation when we're sort of quickly reformulating the kinds of compromises that we've struck over a long period of time.
Thoughts, comments? Everyone agrees.
Exactly what I was going to say.
I mean, I guess I would just say that I think with regard, I guess we're going to talk about the conflict between religious liberty and LGBT rights maybe later, but I would just say, since follow on what Nelson says, I don't get the sense the Supreme Court really wants to issue a definitive ruling in that area and resolve that conflict, because the cases that have come up, the court has really, and sometimes in a kind of embarrassing way, dodged the serious issue by coming up with very, nuanced, is I guess a polite way of charitable, nuanced distinctions or issues. Like in the Masterpiece Cake Shop case, it went off on some comment that one of the commissioners had made. In the Catholic adoption case in Philadelphia, they interpreted the law in a really kind of creative way to say that Catholic services wasn't a public accommodation under Pennsylvania law. And as someone who teaches federal courts, the idea that the court was deciding a state issue like that is just a little strange without getting a lot of briefing on it. So I don't think and in 303 Creative, which Liz mentioned, I think they're going to probably come up with a very narrow ruling that says, well, maybe she's not a public accommodation, the web designer. Or they'll say, well, web design is different because that's speaking things and that it doesn't apply to caterers. I don't think they really want to
I
definitively.
mean, in 303 Creative, they did not grant cert on the
free exercise
question. So I think they were looking for a way to not have that be a religious liberty case, but rather a speech case.
I think they don't want to definitively resolve it. I think they're waiting to see what happens in the culture, and they're sort of really trying to find narrow ways to decide this. Maybe I jumped ahead. I don't know, but it was when Nelson was talking about the conflict. That's what struck me.
I mean, something that strikes me in your comment, Mark, is that we tend to sort of the way I framed a bunch of these questions and the way that I think a lot of us think about these things is very court centric, right? What's the court going to do about this? But I think you raise an important point that sometimes the court wants to see what are we going to do about this, right? Before it decides what should happen next.
And so several of the compromises that I listed were legislative in nature, right? I think the court is happy for that to happen. On the other hand, they did grant cert in 303 Creative, right? So like they've got an appetite for deciding these cases. Although it's true what Mark says that like they're deciding them narrowly and in quirky kinds of ways.
So I guess the most recent of those narrow and quirky decisions was when it was not a 6-3 court. So
yeah,
we'll see.
We'll see. Well, I don't know. Fulton was 6-3 court.
Yes, that's right.
And that case was decided unanimously.
Yeah, that's right.
Yeah.
That's right. And they got some of the progressive justices to join the opinion, which I guess, of course, Nelson, you've written about also that the concept of appeasement, right? If that's not how I'm saying that's the way you can count it. I'm not saying it's. You should read Nelson's article on that.
Liz, Giselle, do you want to add?
I was going to say almost the exact same thing as Nelson. There's been a long-standing compromise that I think gets often lost when we talk about like creating a new compromise. The other thing I think is we kind of talked about earlier is that it's often framed as kind of, as you said earlier, like a religion versus secular rights. I think we do often lose that there is often religion on both and all sides, and that there are some subset of religious believers who certainly feel like they would benefit and have more religious liberty being granted these religious exemptions. But I think the law can often be very bad at kind of zooming out and thinking about a much more kind of broader sense of religious pluralism, and the fact that for a very long time we found that a pluralistic and open economy is actually better for religious liberty and religious diversity than kind of poking holes in civil rights law.
Just that I would agree with what she just said right now. I would say the same thing.
Can I ask a question?
Sure.
All right. My question is for you, Giselle. I'm curious because I see the tension, but I'm curious about this employment discrimination case, Groff against DeJoy, that the Supreme Court is deciding now, and the position that your organization is taking on that case. Because it's true that, as a kind of top line matter, you might think that if the court were to broaden the standard so it's easier for religious employees to get exemptions from workplace rules, that would benefit religious minorities, right? Like I see that.
Mm-hmm.
However, the record of courts when it comes to granting exemptions for religious minorities is not great. Even like the Warren Court, right? Like ruled against religious minorities again and again and again. In fact, there are very few cases where religious minorities won exemption claims, even when strict scrutiny was the rule that was supposed to protect them. So on the one hand, like I worry a little bit about what could be, whether it would really benefit. And then I also worry about whether a broader rule would harm religious minorities, because the religious people who are most likely to benefit from a broadened exemption are, mainstream religious actors who want to sort of take, sort of Sunday off, even in a 7-day workplace where a union agreement has like very, carefully apportioned days off, right? In a seniority system, suddenly, a Christian who wants to take Sunday off, or a Seventh-day Adventist, well, that's not a good example, will be able to jump the queue, and that could impact Sikhs who, don't observe a Sabbath, right? Along with every other employee. So I don't know the right answer here, but I'm just like curious to know how you guys have thought through that issue.
Yeah, very good question. I don't know the answer either. I will tell you, it's one of my biggest internal conflicts right now on the work I do in that case, because obviously we have signed on to amicus briefs at this point, but we had to question whether we would or not and how we think about it. A few things I would say. One, I can't speak for all the communities and other people doing other work. The people I represent, it comes down to usually uniform and grooming, which is really interesting when you look at like what type of religious exemptions we're talking about. I think we kind of, I don't blame anyone, but we kind of automatically think, oh, it's, praying, or it's a certain belief that is, anti-abortion or whatever it may be. For them, it's really their identity. It's just what they look like. And we're not used to it in this country, but that's literally what they look like, right? So that's one thing that I think is just an element I wanted to add. On your question, I don't know the answer. I think when it comes to the undue hardship standard, when we look at it through, again, the context of accommodations to, uniform standards or sort of, what is it called? Company dress code, whatever it may be, because it's not always uniform services, right? I talked about the Marine Corps. It can be a private company that has a certain, dress code, whatever it may be. On that standard, I think because of the precedent of FIHA in California and how many cases we have seen come out of that, and we kind of followed the trends and how it was interpreted, what kind of claims were brought, it did actually end up helping a lot of minorities. I'm not at all saying that would extrapolate to the rest of the country or to the federal level. It's, California, it's a certain state in a certain context, but it was huge, the difference it made. There's just like many examples of, in this case, again, it was a police officer, so it's kind of related to law enforcement, but I believe California might still be today, I think, the state that like accommodates the most, I guess, in law enforcement in terms of, again, not just sex, right? A Jewish member, you mentioned it earlier, sometimes we forget, also have beards. Muslims can have beards for religious reasons. The hijab that we think about too when it comes to the uniform. So that's one. I think because we had that background, again, I don't know for sure, but we feel that in the balance of what it might inadvertently do, it will still protect when it comes to those exemptions. I don't know. I really ask myself that question a lot, and especially as a civil rights org, right, that works in this space that is religious freedom. So we're sometimes not with, other orgs that are in the civil rights space. Sometimes they're more in the conservative space. That happens because we work, on religious freedom cases. And I wonder that I, as a civil rights lawyer, working on those cases, signing on to amicus briefs, on the Graffiti de Joie as an example, inadvertently taking away rights from someone. I mean, it's as simple as that, I think. So yeah, that's how we think of it in that specific context. But it's tricky. It's really
and
tricky.
it gets to the question of, does there need to be a conflict, right?
And the
right.
third party harm, right? Again,
Exactly.
I feel like I'm a broken record, but those Sikhs that are wearing turbans and beards, they don't take away anyone else's rights, right? It's about being comfortable with what they look like, with the fact that we're not used to seeing. I mean, I don't want to get into the whole post 9/11 history, right? But there's a reason they're seen this way, and it's unfortunately not getting better. And so I think you have to wonder that too, right? We're talking about, people that have views on healthcare and taking away someone else's rights, whether it's the Marine Corps or a private company, quite literally, you're not harming anyone else, right? This is just the way you look. So I just want to bring that back into it because I think we forget sometimes.
Well, I'm keeping an eye on the clock, and I want to make sure we have some time for Q&A from the audience. So if anyone has a question, raise your hand. Katie, if you want to bring microphones around to folks. Why don't we start right here in the center? You're a first-year student, right?
In my dreams. Actually, I wouldn't want to go through law school for the world. I'm curious as to the place of atheists in this construct. You've been talking about religions and exclusively, even the nuns, your nuns. You talked about them in the context of that they have beliefs and they have faiths and things that. So where do atheists fit in the jurisprudence? Have there been cases about the right to follow atheism?
Yes.
Nelson's the expert on this. He has a great article about this.
Yes, there have been. So one way of thinking about the definition of religion, like what counts as religion for purposes of constitutional law, is to, and this has been proposed by Doug Laycock, who's like a major, like maybe the leading religious freedom sort of expert in the country. or one of the two, let's say, is it's any answer to a religious question, right? So if the question is like, does God exist? And your answer is no, that counts as religious under his kind of definition. My own view, though, would be like, it's what we need to do is think about the values that are underlying and animating any particular religious freedom provision in the Constitution, and ask whether those values would indicate that non-believers should be protected in the same kind of way. So, and in some cases, it's very clear, like anti-discrimination provisions in the Constitution that say, the government can't discriminate invidiously on the basis of religion, I think clearly ought to benefit non-believers and has benefited non-believers, right? Like in actual court cases, not necessarily in the Supreme Court, but in lower courts and state courts and so forth. A tougher question is like with regard to religious exemptions. So let's say you think that the value that underlies religious exemptions, that people should be able to practice their faith without undue interference or burden from the government, right? Unless the government has a good reason, you should get an exemption from restrictions that the government places on your ability to practice. Some people say like, well, because non-believers don't have any beliefs, it's impossible for them to make that kind of claim, right? Like what kinds of beliefs or practices would they need to engage in that could be substantially burdened by the government? But there have been cases actually about this, even before the rise of the nuns. So some of them have to do with prisons. So let's say you're in prison, you're an inmate, and you want to sort of receive atheist literature in prison. I mean, there are often strict regulations on what kinds of literature you can receive in prison, but you want an exemption from those kinds of rules, or you want to meet with other atheists, to sort of discuss atheism, right? Both of those kinds of claims are like quite analogous, right, to the types of exemption claims that are brought by religious inmates, right? And religious inmates are often successful in bringing those kinds of claims. So, and the inmate context is not the only one. I think you can think of analogous kinds of claims in the military context and so forth, right? So there have been those kinds of cases. They have been adjudicated. Atheists have won some of them. They've lost many others. But it's at least, as a theoretical matter, possible to think through, right, what kinds of protections the Constitution and other religious freedom laws ought to afford to non-believers.
There's a question on the chat from a student that I want to sort of pose to the group in a form, which is, there's, as with a lot of civil rights litigation, right, there's movement lawyering happening, right? There's a movement behind a lot of, there was the NAACP was an LDF, a movement behind desegregation, for example. I don't mean to draw the analogy that I'm about to draw, but just to say there's in general movement lawyering. The student observes that a lot of the cases we've been talking about have been argued by or advanced by, whether it's Alliance Defending Freedom or the Becket Fund for Religious Liberty. Right? There's a legal movement behind a lot of this litigation, as well as, of course, actual individual plaintiffs. And so the student says, I think it's easy to see these as individual cases, but there is this powerful group behind the trend that can often be pretty explicit about some of their goals. What do you think their end game is, and how far do you think this could go? I don't mean to ask any of you. I don't mean to put anyone on the spot about a particular organization, but rather to think more broadly about sort of end game of movement lawyering in the religious liberty space. Giselle, you had mentioned a little bit the bedfellows that you might find yourself with sometimes in these cases.
This is a very interesting question. I'm just reading the cases they cited. I mean, I wouldn't even want to dare to tell you what I think their end game is. Like, I have so many thoughts about this, so I don't know. But one thing I will say,
I didn't mean to put you on the spot.
No, it's okay. One thing I will say that is kind of uncomfortable, but I'll talk about it because I think it's interesting. You said Becket Fund. Very good example. The Marine Corps case I talked about before, Tour versus Berger, there are co-counsel. Mm-hmm. The Sikh Coalition is historically a civil rights organization created after 9/11 to defend Sikhs who were being attacked on the street after 9/11. The Becket Fund, if you know, probably, right, the types of cases, I mean, we're on the other side of them, quite literally on every single big case, right? We sign amicus briefs against them. it's a long story. I wasn't there at the time, so I can't speak for myself, but this is a decision that was made back in 2009 when this, I guess, military campaign, you could call it, started talk about movement lawyering. I mean, that's how it really changed, the system, right? Over a decade, but it did change the system. Why am I saying this? Yes, that was a decision that was made at the time. Obviously, I don't think it would be made in the same way right now, but in a time and a context where the people, at my organization, we knew that we needed that buy-in, that it was going to be a political case. It's the military. The courts, historically, for good reason, sometimes do defer to the military. There's a real, the judiciary not interfering with the military's decisions when it comes to, national security, right? We defer to the military. They're the experts. So we knew back then that that was going to be something that needed this sort of, I guess you could say, political buy-in. I mean, it's a bit awkward, but it's true. And it worked. I mean, Beckett Fund, they win their cases, right? They're extremely respected by a certain, area of judges, of courts, of whatever it may be. So I can't tell you what their agenda is. I think I know what it is. I don't really want to work on it. But I think what I would say is, as someone, I don't know where you all want to work when you graduate law school, if you do, if you're in law school currently. But what I think about as a civil rights lawyer is, yeah, it's tricky. How do I reconcile, right? Associating, or it's a hard word, but like working on a case with co-counsel where we actually really differ on positions on super important cases. One way that I think about it is, maybe that's why it's important that we're a part of it. Like, think of it the other way around. It's not an ideal answer, but it's whatever end game there may be, whatever agenda there is. That's how the civil rights movement worked, right? There has to be people who keep pushing. And so, I wouldn't want the Beckett Fund to take those cases alone. I think it's better that they have a, more minority organization involved. Tough question.
Liz, I feel like you want to.
Yeah, I'll say a couple of things. I mean, they've already accomplished one major goal, which is overturning Roe v. Wade. On that note, one thing I want to note is it's not only like a massive movement lawyering from the Christian right, but there's also, I think, been a kind of corollary lack of investment on a robust, pluralistic vision of religious liberty in more liberal and progressive spaces. A lot of times, the Beckett Fund is the only game in town. If you're a small mosque and you're facing, problems starting up, or at the zoning board. Not to say that there aren't great organizations like the ACLU who do some of these cases, but I mean the disparity in funding and just the number of lawyers working on this issue is just like, I mean, 10 times is probably an understatement, honestly, in terms of the amount of resources and attorneys working on religious liberty issues. And so, and a lot of times, I'll reach out to a small grassroots religious organization, and they'll say, like, we love these Christian rights groups because they care about our issues, right? And no one else is really reaching out. So I just want to say, like, yes, there's a huge movement lawyering going on the right, but I think we need to really be thinking critically about what kind of investment in like a robust, affirmative, progressive vision of religious liberty is coming outside of those spaces.
Great point.
Mark, do you want to speak to it?
Well, no, I mean, I don't hold a brief for the Beckett Fund particularly, but I guess I know some people who work there, and my sense is they genuinely believe in this cause. I don't think, I don't want to let lie a possible implication that this is all sinister, or, I mean, I think they genuinely believe in this too. So I'm not affiliated with them at all. But I would just point out that too.
Yeah, sorry. Okay, I do want to correct that, because also I have a lot of respect for my co-counsel. They're brilliant attorneys. So really, that I will say on I don't think, absolutely. It's super interesting. Out of all, if you look at it historically, all the more, you could say, conservative religious organizations, the Beckett Fund, I mean, they do amazing work. Like some of I can't remember which one, but there's a Native American religious land case, a huge one recently. They were, again, right? Like they genuinely believe in religious freedom and take cases that are huge when it comes to protecting religious minorities. And I do fundamentally believe that when, they represent my clients with me as my co-counsel, they of course, believe in the rights for Sikhs to practice their faith the same way someone else should. All I meant is, it is tricky to work in this space where we agree on a certain point, but sometimes we don't agree on another one. And that does all fall under religious freedom. And that's why it has to be maybe, pluralism, like you called it, diversity. I think that has to be the answer.
The question back there.
Back.
Okay.
Oh, I had. Okay, I'll get you next. From you.
I think it's for anybody. I think it's a great question. I mean, I'll add my own spin to it, which is when we talk about look, legislators who are and executive officials who are well lawyered and well advised will try to make policy in ways that they think will be insulated from judicial challenge, right? And so I think what the question is getting at is there something to be, is there some sort of strategy that one might either is or might employ to sort of frame, for example, anti-LGBT legislation as rooted in religion and therefore make it more immune, or not immune, but make it more resistant to judicial challenge? Or would that, I'm just going to start answering the question too, right? Or would the state's religious imprimatur or motivation behind that legislation actually doom it rather than help it, because now you've created an Establishment Clause problem?
Yeah, it really depends on the type of legislation that you're talking about. I mean, the type of anti-trans legislation or homophobic legislation that is at issue. I mean, lots of examples come to mind, but right now, the Biden administration is in the middle of a proposed rulemaking. Again, this is outside of courts, right? To rescind a rule that the Trump administration put in place in universities. Okay, here's how the Trump rule said that if you're let's just say like a progressive university and you want to require student groups to not discriminate against protected classes in order to qualify for like student group funding, right, from the university and so forth. You can't deny that funding to a student group if their discriminatory beliefs are rooted in religion. So that's a kind of like religious freedom type of rule, right? And you can see how in that kind of context, protecting the right to discriminate for these groups is grounded in religion, right? Now the Biden administration is going to roll it back, but you can see the move there, right? On the other hand, in other contexts, like just passing an anti-trans law with a religious motivation at the legislative level is unlikely to insulate it from any kind of judicial challenge, but also unlikely to raise any kind of Establishment Clause problems, because usually these kinds of laws are passed by a multi-member body like a legislature, and who knows like what everyone's thinking when they vote yes, right? Even if people say like outrageous stuff on the legislative floor about like God made me do this and so forth, which has happened especially with respect to abortion restrictions. It's under existing law, it'd be very hard to strike down any of those laws as Establishment Clause violations. So so it really depends, I think, on the type of restriction. I guess that's what I would say.
Tanisha.
Thank you. Thank you for being here tonight. I wanted to ask a little, are you familiar with the caste equity movement and caste discrimination? Yes. So just to contextualize this, when the Cisco suit came forward, a bunch of tech workers talked about caste discrimination in the workplace, and the California Civil Rights Department is investigating, but then the Hindu American Federation said that the investigation was Hindu phobic, misportrayed them. Seattle just passed an ordinance last week banning caste discrimination. So because caste sits at like the intersection of race, ancestry, all these things, I'm curious if you have thoughts of how we as a society in the US should think about caste, where that falls on the spectrum of religious liberty. Asking for a friend.
It's a great question.
I guess I could say just from the Sikh perspective, I don't know. I'm sure you all have other things to add. Because I did see someone sent it to me at work. Seattle, right? Just past. Is it the first in the country? I can't remember. Okay. That's pretty cool. What I would say is it's something we, unfortunately, as an organization that is still pretty small, have not yet have the resources to dig into, but we do follow what's happening because I guess my answer would be, I mean, it's discrimination based on what should be a protected class, just the same way we have other laws. It's just sort of an education issue in a way, in the same way we had to, you know, do a lot of work to educate the American people and the government about who Sikhs were. I think there's this, we don't understand caste really in the US. I went to school in France, so I don't know where you all went to school, but I don't know if here you learn about caste. I didn't in France. So I think it's a lot of that, honestly. I don't see legally, and again, the experts here, I'm just a practitioner, not a professor at all on like Supreme Court jurisprudence or anything.
It means you're
To
actually
me-
the expert. Isn't it?
Just the practice of laws, but to me, it's obvious how I don't see the difference between if we believe in the reason why we have protected classes and categories in civil rights. To me, caste discrimination obviously falls under that, I guess, is my answer.
Just the doctrinal answer, right?
Yeah.
I would agree. Like it ought to be, and you know, under black letter law is that civil rights protections for protected classes do not admit religious freedom exemptions. The leading case was one from the civil rights era where a restaurant was excluding customers on the basis of race and brought a religious, like a free exercise sort of defense, which sounds similar to that situation. And the Supreme Court dismissed it in a footnote. And that footnote was recently endorsed by Justice Kennedy writing for the majority in Masterpiece Cake Shop. So it has some legs, I would think. But that's not to say that settlement is stable. As I was saying before, like it's longstanding, but we're seeing a lot of movement in these areas of law. So I don't know what would happen in the future.
Right, any final questions? We are roughly at the end of our time. We have a reception outside in the lobby. So I hope you'll all join us there and continue the conversation. But before we do, we thank our tremendous panelists. Thank you, guys. And thank you all for coming.